Due to the events of the past year and the current COVID-19 crisis, I decided to do my presentation on the Emergencies Act. Over the past year, the Emergencies Act has continuously been mentioned in the news cycles by political commentators, our federal government, and even local union activists. And as the number of infected people increases, the resources and equipment are scarce in our country, and smaller regions are unable to support victims of the virus within their own communities. As a result, both politicians and local leaders are calling on the Trudeau government to take a bigger step and invoke the Emergencies Act in efforts to flatten the curve. Now the question is, what does it really mean for the federal government to invoke the Act? How will their powers change under the Act? And should the federal government use this Act now to respond to this deadly pandemic? First, let's start by defining what the Emergency Act is. The Emergency Act is an act to authorize the taking of special temporary measures to ensure safety and security during national emergencies and to amend other acts in consequence thereof. That means that the power of the federal government actually increases once the Emergency Act is invoked. To understand the Act a little better, let's dive into its history. Before July 1988, the Emergencies Act was known as the War Measures Act. The War Measures Act was passed by the Canadian government during World War I to give the federal government sweeping and unlimited powers to make laws. Keep in mind that at that time, the Charter of Rights and Freedoms had not existed. So there was no way that the people were actually protected from the government itself. So the government passed lots of laws that actually suspended civil rights and liberties. This act was invoked 3 times in Canada, during the First World War, the Second World War, and then lastly during the October crisis in 1970 under Trudeau Sr. The War Measures Act was eventually replaced by the Emergencies Act, which was more democratic and followed the rule of law a little better. The Emergencies Act allowed parliamentary oversight and required cabinet to go through Parliament to make any decisions. It also required that government actions are subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights. This way, the federal government didn't have uncontrollable power to arbitrarily pass laws. So now that we got a little bit of background history on the Emergencies Act, it's time to dive into the Act itself. What is actually considered a national emergency, and when can the government invoke this Act? Under Section 3 of the Act, a national emergency is defined as an urgent and critical situation of a temporary nature that A, seriously endangers the lives, health, or safety of Canadians and is of such proportions or nature as to exceed the capacity or authority of a province to deal with, or seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada. We must bear in mind that a national emergency has to be one that cannot be effectively dealt with under any other law that currently exists within Canada. Next, we're going to explore in detail the different types of national emergencies that are covered under the Act. We're specifically going to dive into public welfare emergencies, so I will explain that a little bit more later on. Public order emergencies include any sort of situation that could threaten the security of Canadians and lead to a national emergency, and international and war emergencies along the same lines and are pretty self-explanatory. So diving right into public welfare emergencies, which is in Section 5 of the Emergencies Act, a public welfare emergency is one that is caused by a real or imminent threat by the following: fire, flood, drought, storm, earthquake, or natural phenomena. B, disease in human beings, animals, or plants. Or C, accident or pollution. And the results of any of these must lead to a direct danger to life or property, social disruption or breakdown in the flow of essential goods, services, resources, or be so serious to be constituted as a national emergency as previously defined by this Act. So as you can probably notice, the public welfare emergency portion would apply to the coronavirus in the way, especially in 5 Section B, disease in human beings, which is a lot of the points that are going to be brought up in favor of invoking this Act, which I'm going to talk about a little bit more. later. So we've discussed the circumstances in which the Emergencies Act would apply, but now the burning question in the room: what powers do the federal government actually have if this act is invoked? So as you guys probably know already from constitutional law, that the federal government's jurisdiction is over national defense, foreign affairs, oceans and fisheries, the Bank of Canada, criminal law, public safety, etc. Under the Emergencies Act, the role of the federal government itself is expanded to include some jurisdiction that's traditionally under the provincial government. This could include several things such as regulating or prohibiting travel to and from within specific areas, evacuating people and removing them from their personal property for their own protection, directing a class of persons to render some sort of essential service that's needed during this time, regulating the distribution and availability of essential goods, services, and resources as well. Other things that the federal government can be mandated to do is to actually authorize and make emergency payments, establish emergency shelters and hospitals, assess damages that need to be done and need to be replaced, assessing damages to the environment, imposing fines and indictments on individuals who refuse to follow certain regulations that are passed within the four corners of this act. By enacting the Emergency Act, Parliament is clearly delegating considerable power to the Cabinet in these extraneous circumstances. So as law students, we of course beg the question, what is the court's responsibility in all of this? So the courts do have a responsibility to oversee how Cabinet exercises its power. A judge would discharge this responsibility by applying the principles of administrative law in the judicial reviewing process. And of course, the Emergency Act in its preamble acknowledges that the Cabinet's actions under the Act are subject to the Charter and other domestic and international human rights instruments, and it's the court's job to maintain that and hold them accountable to that as well. Should the federal government invoke the Emergencies Act to protect Canadians from being more at risk to the coronavirus? The Trudeau administration has stated that they have been in correspondence with provinces discussing whether or not invoking the act is an option. And so far, the administration has decided that they can pass laws outside the act that would be just as effective in protecting people. An example of this is the Quarantine Act. The government also claims that it trusts that the provinces will be able to mandate rules and regulations for their own communities because they understand their communities' needs better than the federal government may. That being said, cases in major cities are still rising as we are hit with the second wave, and essential workers, especially in smaller areas, lack the proper resources and PPE needed to effectively treat patients and contain the virus. With several major cities going back into lockdown and increasing anti-mask movements, economic distress, defiance of quarantine regulations, and the recent discussions on interprovincial travel bans, maybe the federal government will finally change their mind and decide to take charge and invoke the act. What do you think is the best course of action?